So what you essentially had were different rulings for similar crimes across all of England, based on local custom. So what Henry II does is he says, no, this is unacceptable. What I would like to do is to standardize the rules across all of England. Create a bank, a body of English custom. So we have what is now known as common law. Essentially what we're saying is that common law are a series of principles, a series of concepts, ideas, all of which are being applied to society via a system of centralized justice. And this is being applied in a uniform manner across the whole of England. The idea is that all the judges are going to be drawing from the same body of customs. So the term common law, in fact, simply refers to the principles that have evolved over many centuries in British courts. Over time, a rule known as stare decisis, or precedent, developed that required judges to follow decisions of earlier judges. You know that we have common law in New Zealand. Why is that?
Because we were colonized by the British.
Precisely. Parliament creates laws, it enacts laws, and it enacts laws via statute. So a statute is simply a legal rule that has been enacted by the sovereign. Statutes are intended as a means of codifying and implementing governmental policy. There are different types of laws, different types of statutes. The easiest one are what are known as public acts. Public acts, public statutes. These are applicable to the general public. Second type of act we have are referred to as local acts. They apply to a particular locality. Third type that we have, a private act. A private act concerns an individual or a handful of people. These are extremely rare. Now, although most statutes are enacted by Parliament, some of the statutes that we have in place came from Britain because of New Zealand law. So New Zealand law said specifically these British statutes are applicable here. So we have an example, would be the Bill of Rights, 1688. Britain no longer has the power to legislate laws in New Zealand. Now understand that there is a relationship between common law and statutory law. Common law has essentially informed statutory law. The common law is retrospective or backwards looking. The judge is saying, okay, a crime was committed in the past. How am I going to resolve this? Statutory law is prospective, forward looking. This means that the sovereign is deciding that the rules that are going to apply for this particular behavior in the future is as follows. So judges now don't have to look to precedent anymore because the precedent has been overruled by the statute. At the heart of New Zealand's legal system is this concept of parliamentary supremacy. Parliamentary supremacy. What this means is that if a common law contravenes, conflicts with a statutory law, the statutory law wins. Statutory law trumps common law. And what this also means is that Parliament can enact any law it pleases, even if it happens to contravene centuries of established custom. In practice, however, it's not that simple. Judges ultimately accept statutes because of parliamentary supremacy. But the judge is still interpreting the law. They're still interpreting the statute. And they can interpret it in many which ways. So even though it's not as flexible as common law, there still is room to maneuver. There still is room to maneuver. The point, what you should take away from this, is that parliamentary supremacy, in theory, is very straightforward, is very clear. In practice, however, it's a little more complex. Two cases were particularly important in this. One is the case of proclamations. In that case, it was ruled that the king has no power except that which the law grants him. The second case, prohibitions del roi. Prohibitions del roi. That case held that the king is subject to no man, only to God, and to law. In New Zealand, we do not have a supreme law. Ergo, Parliament has final say. So Parliament can turn around and say, hey, you know what? I don't really like this Bill of Rights Act. I'm getting rid of it. Now we laugh and we snicker and we say that's unlikely to happen. But what happens frequently is Parliament turns around and says, you know what? This new law that I'm establishing is in breach of the Bill of Rights Act. But too bad. This happens regularly. And it can do so because the Bill of Rights Act is merely an ordinary statute. Now, whether or not Parliament can breach certain human rights conventions, certain basic rights, is a matter that is being debated. There was this excellent statement by Lord Cook, famous New Zealand judge, who said, some common law rights presumably lie so deep that even Parliament could not override them. Some lie so deep that even Parliament could not override them. Other English judges have argued there are limits on the supremacy of Parliament, and there are some things we are just not willing to accept. Once again, torture being a fundamental example. Can Parliament tomorrow decide that people can be tortured? The answer is yes, Parliament could. Would it hold up in court? The answer to that is unclear. And you have to think about it. What is at stake in the end is the separation of powers and what this means. The legislative Parliament decides the law. The executive implements the law, executes the law. The judiciary resolves disputes about the law. The judiciary is saying, you know what? You can enact that law, you can implement that law, and maybe, under certain circumstances, we are not going to apply it. So in the end, who's deciding the law? Is it Parliament, or is it the judiciary?